just so I don't forget. It is probably going to ask you to accept that you're okay being recorded. So again, welcome everybody. I'm Jessica Lawson with the Peace River Center Community Relations team, and we have with us Kirk, who is going to be our presenter. I will get to his impressive bio in just one moment, but real quick, I wanted to first say welcome. Again, I know we just had quite a few more come on, so I wanted to let you know you are in Zoom webinar mode, which means your camera's off, as well as you won't be able to have the microphone on. Sorry, I just got distracted with a question. Yes, you will be able to receive the recording, even if you can't stay for the whole time, or if there's something that you've missed, that's why we're recording it. Feel free to use the Q&A, the chat feature like that was just done, or the raise hand feature. I wanted to real quick put a plug in. Kirk and I oversee our Junior Advisory Board, which is a group of driven high school students who learn more about mental health, mental illness, victim services. They advocate with their peers and out in the community to raise awareness. They conduct donation drives. So if you have any students, whether your own kids or high school students who might be interested, I'll definitely include that in the follow-up email that we send out, but I just wanted to give that quick plug. I know quite a few of you really are interested in this topic, and I wanted to mention that we do offer mental health first aid training. That will also be in the resources that come out. So that is a much more intense, in-depth look. It's a whole day training. So if that's something that's interesting to you, I will make sure that you get that resource as well. And then lastly, I wanted to invite you to our next webinar, which is actually next Wednesday at noon. It is a convo with our CEO on how to make it okay to talk about mental health. So our CEO, Bill, will be sharing tips on how to reduce stigma, what is mental illness, and so forth. So you can head over to our website, peacerivercenter.org, to register for that. And now to our main attraction. Kirk is the Director of Crisis Response Services. He has been with Peace River Center for 20 years, and he was actually responsible for creating the Mobile Crisis Response Team. He has more than 30 years experience in various mental health and psychiatric emergency health care. He holds a master's degree in social work and also a bachelor's degree in psychology. He's a licensed clinical social worker in Florida, and he's also a trained, which is very awesome, a trained hostage negotiator and a certified field traumatologist. So Kirk works very closely with law enforcement and is often called out to those situations that we later hear about, but Kirk, much like the police officers, is one of the first on the scene sometimes. He is a former regional director for the Florida Suicide Prevention Coalition. Kirk also offers a very wonderful, insightful presentation on suicide awareness and prevention. So if that's of interest for you, we actually have one on demand, or Kirk is always happy to book another one if you want to present it to your group or to your class or so forth. He is a certified instructor for crisis intervention team, again, works very closely with the local law enforcement. He's been a trainer for the Polk County Institute of Public Safety, basic hostage negotiations. This list just goes on and on. He's done tons of workshops. He's a consulting member of the crisis negotiation teams with the sheriff's office. He also works with Lakeland PD, Winter Haven PD, you name it, Kirk probably does it. He has served as a subject matter expert and also is a professor at Florida Southern College, an adjunct professor. So without further ado, Kirk, thank you so much for sharing this important information.
Well, thank you so much, Jessica. And hello, everybody, and I'm glad everyone is here. I do want to say, yeah, it's going to be a daunting task to compress everything into a 1-hour presentation because, as Jessica mentioned, this is usually easily a half-day presentation, and even then, we're not covering everything that is in the Baker Act statute. So I'm going to share my screen so we can get started here. Thank you all for all of you who submitted questions in advance that helped kind of shape some of the focus of the presentation. Also, I want to say that up front, I am not an attorney, so I cannot give legal advice. I just want to throw that out there. I do know the Baker Act statute quite well, studied it at length and some of the ancillary statutes that go along with it, and have trained with some of the various known experts in the Baker Act law here in Florida. So what I'm going to present today is is on some of the material for the process, hopefully answer some of the questions that have been out there, but there will always be more questions as the statute continues to be modified, as it has been recently, especially when it comes to juveniles. I do want to say right up front that a lot of what's in the Baker Act proper is really designed for adults. We'll get into some of that history. There have been some pieces added to it where juveniles have been added on there, and how that impacts. It is slightly different when it comes to juveniles in some areas. So here we go. Let's launch into the formal presentation here. We're talking about the Baker Act, but it is formally known as the Florida Mental Health Act, Chapter 394. We call it the Baker Act after one of the key representatives who championed the cause for the law. We're going to get into some of the background, some key definition terms, what the legislative intent was, and then we're going to look at two criteria: voluntary admission and involuntary examination criteria. Those are the two big areas within which the Baker Act people think about when they hear that part. So
I forgot to launch our poll to get a pulse on who all of our attendees are. Are you good if I pause you right there and I'll launch that poll real quickly? I know that we have a lot of people from the school board, so we wanted to, or rather from Polk County Schools, so we wanted to go ahead and just kind of get a feel. You should have that poll on your screen now, so if everyone can just answer. And I know we do have others who are not within the school system, but trust us, a lot of those registrations we got, I would say probably 60 to 70% were from the school.
Cool.
Perfect. Love it, love it. Thank you for interacting with the poll and letting us know. Kirk, are you seeing the poll on your end too?
I am, yes.
Perfect, okay, making sure. All right, we'll give everyone a couple more seconds. 32 out of 42 is not bad. All right, so we have decent spread: guidance counselors, some in school behavioral health counselors. I think a lot of our people who are actually here today might be the ones that do not have students in their classrooms right now. Perfect, thank you.
Nice. All right, so looking at the background of the Baker Act, there have been statutes in place for individuals and the treatment of individuals with mental illness since 1874. They've been in place, but the dramatic changes did not occur until the early 70s. And that is when the Florida Mental Health Act was enacted. It's best known as the Baker Act, and I'll show you why here in a minute, in 1972. So what that did was strengthen due process rights for individuals with mental illness, as well as their civil rights within treatment facilities. And there's a lot of information about those rights and how things are supposed to be done at some of these facilities given certain interventions and such, none of which we'll get deep into here today. And from 1972 to about 1996, there were no real substantial revisions, little tweaks here and there, but in 1996, things changed to strengthen the rights even more so, and really clarify the role of law enforcement in the whole process, okay? And so what I have here is a quote from Maxine Baker. There's Miss Baker right there. She was a representative, a state representative from down in the Florida, down in the Miami area. She championed the cause for the rights of individuals and brought it to the legislative body to get this, what we know as the Baker Act. See, here, I love this quote from her. "In the name of mental health, we deprive them of our most precious possession, liberty." So I always stress this, as people think of the Baker Act, and I often hear it spoken about in a very glib, off the cuff kind of manner. But really what people need to understand is that when we initiate a Baker Act, we are actually taking somebody's freedom away temporarily. And there's nothing more valuable in America than our freedom. And so this is a serious matter. If we feel somebody is so ill and so disruptive that we have to take their liberty away, it's going to be a pretty serious act, and we shouldn't be looking at it in such a glib manner. It's a pretty important piece of legislation here. Now, the intent was to allow for emergency service and temporary detention for evaluation and treatment. The temporary part being up to 72 hours. That is an important piece to understand, because a lot of people do have the misunderstanding that once a Baker Act is initiated, they are getting long-term treatment. I'm here to clarify that no, it's not long-term treatment, but it's the start, or can be the start, of long-term treatment. A lot of things happen in a short window of time, that's 72 hours. Not everybody has to stay the full 72 hours. The statute says up to 72 hours. We'll get into a little bit more about that evaluation process and what that is about. It also set up guidelines for voluntary admissions and allows for involuntary evaluation and placement. And we're going to hit those things. Now, some of the things that the law does not cover when we get into some of the terms here, first and foremost, is not for those individuals with primary substance abuse issues. That is for the Marchman Act. So if somebody is coming to the attention of law enforcement, or you've got a loved one who is presenting a problem because of their substance abuse issues, they may have co-occurring, they may have substance abuse and mental health disorder issues. But if the primary issue is substance abuse, the Marchman Act is much more appropriate for that individual and much more appropriate intervention. We could spend another hour or more on just the Marchman Act. It also does not cover individuals with developmental disabilities. That's Chapter 393. There are certain primary diagnoses for individuals on the autism spectrum, where yes, they may be acting out behaviorally, but it is not really appropriate to do a Baker Act on that individual. Now, can individuals with developmental disabilities have co-occurring or mental health kinds of issues as well? Absolutely. So we've got to be very particular on what we're looking at here when we initiate the Baker Act. Is not within the abuse, neglect, and exploitation of vulnerable adults. That's Chapter 415 primarily. While there are certain things there, can older adults have mental health conditions along with some of their medical conditions, and that is true as well. And it does not replace the Federal Emergency Medical Treatment and Active Labor Act. It's an anti-dumping law that's primarily for the purposes of hospitals or hospital-based programs. Freestanding psychiatric facilities, freestanding crisis stabilization units are not covered under that particular law. All right, so let's get into some key terms, because these terms are important as to how things happen and what takes place with some of the processes we're going to get into. And first and foremost is the term mental illness. So here is the legal term for that. I do want to point out that with my slides, I do have where in the statute you'd be able to find this information. I've paraphrased some of it, and in some cases I've quoted verbatim the information. So if you want to look up the statute yourself, you're welcome to do so. So mental illness is an impairment of emotional processes that exercise the conscious controls of one's actions or of the ability to perceive and understand reality, which impairment substantially interferes with the person's ability to meet the ordinary demands of daily living. So there is the legal definition of mental illness. It does not include developmental disabilities, conditions manifested by dementia, substance abuse impairment, traumatic brain injury, or antisocial behavior, which is a different kind of condition. Again, another full presentation on any one of these would be important. So this is a process that's interfering with one's ability to function day to day. Express and informed consent. This is where a competent person is able to, after a sufficient explanation, is able to understand and make a knowing, willful decision without any element of force, fraud, deceit, duress, or other form of constraint or coercion. And the reason I'm stressing this is I have heard from time to time at various locations where somebody will be told, well, if you don't sign yourself in voluntarily, I will write the Baker Act. Well, they're pretty much null and voiding the express and informed consent at that point, because what they're coercing the individual at that point by force to sign a voluntary, and it's a legal document. So if folks are out there and they feel very strongly that somebody needs to be taken into custody because of their mental illness, the involuntary is very appropriate in those situations. Now, this express informed consent, we are all subject to express informed consent whenever you go to the doctor's office and he or she gives you some medication or is talking about a course of treatment with you. They go through a list of questions or topics, side effects, other medications that may be beneficial, why they're choosing a particular medication over another, what you can expect from it. And if something happens, get back in touch with me. All those kinds of informed consent pieces. Same thing we do in the psychiatric world. When somebody comes in for a crisis assessment, for example, at one of our crisis campuses, and they meet with a crisis counselor, and they say they want to sign themselves in, we're trying to, first of all, help that person kind of look at a plan so that they don't have to go on the inpatient. But if it does warrant that, we are going through a litany of questions and bits of information so that the person fully understands what they're about to sign themselves up for when they sign the document for a voluntary admission. Now, what's also important to understand with express and informed consent has to do with whether or not they are competent or not. So if they're incompetent to make that well-reasoned, willful, and knowing decision, they lack that capacity, that could have some serious repercussions on the voluntary. It actually makes it null and void if they are not competent to make that decision. And that comes out of a landmark decision in 1990 that happened here in Florida, and it's Zinnerman versus Birch. The legal brief on it is at that website located here. But basically what happened with Mr. Birch was he was wandering along the Florida highway, had some bruises on him and disoriented. Good Samaritan brought him in for care to a private mental health facility in the Tallahassee area. He signed some papers, got better, got out of the facility, and basically after consultation with some advocacy groups, Mr. Birch was so out of it, disoriented, not understanding what was happening because he thought he was in heaven and everybody was angels. He basically had signed papers, but he did not recall what those papers were, did not recall even signing those papers. And so therefore it was deemed that every intervention that happened with him, every shot given was considered assault and battery. Therefore he won a case. So just because somebody says they want to get care does not necessarily mean they qualify for voluntary admission. They have to be able to have the capacity to make that well-reasoned, willful, and knowing decision concerning their care. So we've had that happen where, well, you said you wanted to get help, but they're totally out of it, hallucinating, being chased after the blue cats from Venus. That does not necessarily make them competent to understand that they're signing or be able to give consent for treatment in those cases. All right. So those are a couple of really key terms when it comes to some of the processes here. We also have some terms that get battered around here, and we've got receiving facilities being one of them. And these are facilities designated by the Department of Children and Families to provide for inpatient, involuntary inpatient under emergency conditions for mental health or substance abuse evaluations. Here locally in Polk County, or our Polk, Hardy, and Highlands County, we cover 3 districts in Circuit 10. We have 5 locations, 2 of which are operated by Peace River Center. One is our Bartow Crisis Campus. We have a Lakeland campus as well. Lakeland Regional has a receiving facility earmark, as does Baycare Hospital, Winter Haven Hospital over in the Winter Haven area, and Advent Health over in Lake Wales. The unique thing about the Peace River sites is that they receive some state funding to have beds available for those who are indigent. They don't have any insurances, so they're able to go there to those facilities. And so the state contracts for a certain number of beds. Not all the beds are contracted with the state, just a certain number of those beds are. The other sites, Lakeland, Baycare, and Advent Health, work on a private basis and work with managed care companies, and will take certain insurances. As a Peace River Center, we take some managed. We have contracts with managed care companies as well.
Rick, we have a quick question. Does Baycare still only receive adults, or do they have a pediatric facility now? Did you want to mention, because Peace River receives?
I do. I was going to do that when I get to transportation exceptions, but I'll throw that in here right at the moment. Yes, there are, because you're designated as a receiving facility, you're basically opening your doors to have people come in who are under the initiation of a Baker Act. Well, there are certain exceptions out there through transportation exceptions. When we get further into the law about nearest receiving facility, transportation's exception plans have been put in place for Winter Haven, Advent Health, primarily because they do not work with juveniles. So Winter Haven does not have the capacity or to take in or admit, I should say, juveniles under a Baker Act. They are working with 18 and older. Lake Wales, if I remember the age correctly, it's 55 and older, might be 65 and older. But they're working with the elderly population primarily there. While Lake Wales has that, there's also Lakeland Regional has a memory unit as well for the elderly who may be under a Baker Act in those conditions as well. Lakeland Regional will work with juveniles age 10 to 18. Peace River Center will work 4 to 18. So we've had some, only a few times, some rather young folks on our children's unit. So there's a transportation exception that takes place. I'll touch on that a little bit here in a moment. So those are receiving facilities. So when somebody initiates an involuntary Baker Act, there are certain places designated by the Department of Children and Families to have places where these people can be brought to. And so those are those receiving facilities. Treatment facilities are what takes place beyond the receiving facility stay. And there are state-owned, state-operated, state-supported hospitals and centers throughout Florida. 2 that cover our particular area are Northeast Florida State Hospital and Florida State Hospital out of Chattahoochee, McClinney, the Northeast Florida, they have a huge waiting list. And so we tend to have more capacity and luck getting individuals into our Chattahoochee facility. Now, Chattahoochee works with both forensic and with civil kinds of situations. So those are longer term kinds of stays for an extended treatment. Used to be about 6 months or so that they could go there. For those that need something beyond just the crisis evaluation. And I'll talk a little bit about how that gets kicked into play for primarily adults. All right, so let's touch upon a voluntary admission, because I've heard individuals say that there's no such thing as a voluntary Baker Act. Well, there is. It's a different status within the Baker Act. It does cover somebody who has some insight as to what's going on and they feel they need admission into such a facility to get evaluated for a short stay. So we have two types of criteria here. So first of all, somebody has to have evidence of a mental illness. They have to be able to have competency to provide that express and informed consent. So they have to fully understand what they're about to sign themselves up for, because you can't sign it. It's a legal document, at which point, when you get back onto the locked unit, you can't go, oh, I don't like the wallpaper, and turn around and leave. There is a process. You still have to be, you can request to leave within an hour of being admitted. And the psychiatrist has to evaluate you within a certain amount of time in order to be released from the Baker Act you signed off on. Right? It has to be suitable for treatment. What's important about that little statement is that, you know, folks come here and they think they can just sleep in the bed all day. Well, no, you have to engage in treatment. You've got to be part. There are some things that do take place on even the crisis unit. While it may not be super in-depth treatment, but it's the start of being part of group processes, psychoeducational groups, being out and interacting with other individuals, interacting with the staff, speaking with your assigned clinician while you're here. You have to engage in all of this. You can't just isolate and just say, I just want to sleep for the next 2 days, 3 days. You have to be willing and understanding that you are going to participate in that. And you cannot be adjudicated legally incapacitated. So if that's the case, then we're looking more at an involuntary. Now, all of that needs to be there, plus some additional things when it comes to minors. Okay, in the state of Florida, minors have the disability of age, so they basically have to, you know, they can't just sign themselves in necessarily, although there is some capacity for 14 and up to be able to sign voluntaries in. That's usually very, very limited. It's the minor really has to be a mature fortitude in order to understand. And typically what happens is if everybody's in agreement, the guardian, the juvenile, and the clinician working with the minor, we can typically, especially with the 16, 17-year-olds, we can see that they may be appropriate to sign themselves in. But that's the important part. There is consent from a guardian or a caregiver, a parent, what have you. They are very much part of that process for voluntary. And the law does require a hearing before a judge to verify that the voluntariness is there, that they are not being coerced or threatened in any way, shape, or form to sign this voluntary, and that they understand a little bit about what's going on. The voluntariness hearings tend to be a challenge throughout the state because you never know when that voluntary admission is going to happen with minors. Okay, and then of course it's the discharge process. So you get in the door. Now, how do I get out? Well, there's going to be significant improvement that they no longer desire, or there is no longer a need for them to be there. And a person can revoke or request discharge either orally or in writing. And they've got to be discharged within 24 hours once the request is made. All right. And then off they go. Now, a lot of folks, once they come to the crisis units, whether it be at Peace River Center or any of the other receiving facilities, they are discharged with some aftercare plan. They're not just let go with, okay, you're done. No, they get some appointments and some guidance with regard to where they can get some follow-up care. In a lot of cases, the clinicians are helping that person walk through some of that process. All right, so let's get to the involuntary, because this is the big one. So involuntary examination has a few things. Now, what's good about this is when, and we'll get into who can initiate those forms. There are various forms for that, and most of the forms have this information on there, so you don't have to memorize it. It's right there for you to read through, up to and including the legal definition of what a mental illness is on the more recent forms. So for involuntary examination, the criteria starts off with, first and foremost, there is reason to believe that the person has a mental illness, and because of their mental illness. Okay, so reason to believe. Working a lot with law enforcement, they often have to deal with preponderance of evidence, where they have to have, hard, firm evidence on certain situations. In the case with the Baker Act, it is a civil matter, and what we're looking for is reason to believe the person may have a mental illness. And that can come from the person themselves saying, oh, I've been diagnosed with bipolar disorder or whatever other disorder. It could be you see several pill bottles and you see it might be Zoloft, which is used as an antidepressant. And it may say right there on the bottle label the person's name and the medication and what it's prescribed for on the label. Reason to believe. Okay, you can have a credible third party there who is telling you Kirk has been diagnosed with a depressive disorder. Got reason to believe this person may have a mental illness. First and foremost, what is the mental illness? That criteria needs to be met. Check. Okay. And because of their mental illness, they have refused voluntary examination after conscientious explanation and disclosure. Have they been given express or informed consent? And they refuse. No, I don't need this help. Okay. Or they're unable to determine for themselves. There's ors and ands here. So on the Baker Act form, for a lot of folks, there are a couple of boxes you check off. So you got to pick one or the other. They're either refusing or they're unable to determine. So you're saying they're not competent to give that express or informed consent in the second statement. And either of the next two, and you'll see that first paragraph, a lot of individuals skip over that lengthy paragraph because there's a lot to read there, and they go right to the second one after the or here, which is substantial likelihood without care or treatment that the person could cause serious bodily harm to themselves or others in the near future, as evidenced by their recent behavior. So you hear, oh, it's a danger to self or others. It's that second part. That first one, that lengthy paragraph, gets into that without care, that they're more than likely going to decompensate. They are not able, they're not with it, they're disoriented. They think they're in heaven and the space cats are coming to take them, to care for them. There's a real potential likelihood of threat of harm or substantial harm if they're not able to get the care. Now, and it's apparent that such harm may not be avoided without the help of a willing family member or friend or provision of other services. So it gets into some sort of least restrictive means here. And now what's important here when it comes to minors is this little statement that may be avoided through the help of willing family members. So a lot of folks are looking at that to say, well, if the parents are willing to have them go get care, the child does not necessarily meet the criteria under involuntary examination. That is technically a way to engage family members. And when the crisis response team responds to calls, that very often is the case, that we're able to look at those least restrictive means, and there's in statute a responsibility to do so. All right. So we could spend a lot of time just on the nuances that go on here, but essentially, if you've got folks that are willing to do that, and there's the person is meeting the criteria, then you've got a likelihood that you could go for a voluntary or other least restrictive means. So let's get into the certificates of who can initiate a Baker Act, the involuntary examination certification. So there's three types. There's the professional, the ex parte court order, and then there's law enforcement. And there's certain wording in here that becomes very important for everybody to understand when it comes to who can and cannot initiate certain things. So from a professional standpoint, under the professional certificate, who can initiate under the professionals? Well, here's a list for you. I'm not going to read the list. Everyone can kind of see that. But essentially, licensed individuals who work in the area of diagnosing nervous disorders or mental disorders have the capability to initiate the Baker Act. So here in Florida, you have to be licensed and have X number of years of schooling, and you have to have an examination that you take, and then you get licensed. Physicians who've had experience in treatment of mental and nervous disorders can do so. So a lot of doctors in our emergency rooms have the capability to release somebody from a Baker Act. And from time to time they do. A lot of them are nervous in doing so because of some liability issues, and perfectly understandable. But no, your podiatrist or your dermatologist could not necessarily do a Baker Act. They would have to call somebody in to assist there. And so I've also heard that people within law enforcement and professionals say, well, under law enforcement, they'll say, well, we have different criteria. No, the criteria is all the same. It's the actionable part that's slightly different between law enforcement and professionals. So professionals, under the certificate that professionals issue, they may execute a certificate. Again, the important word here is may. And that is because we have an obligation as licensed professionals, clinicians, working with individuals who are having struggles with certain things. We want them to talk about these particular issues, but in a safe manner. We can work clinical plans, safety plans with individuals, and we have an obligation under the law that we have to screen for the least restrictive means possible in order to deal with their particular issues. So there's an obligation dictated within the law for professionals, clinicians, with all the additional training and licensing behind them to, work safety plans, work some treatment objectives here. And in our 2-page form, because there's 2 pages for professionals, we have to document our observations and evaluation of what's going on here and why we've come to the conclusion that we cannot do these interventions in the least restrictive setting. So the form for professionals is 2 certificates. Now with telehealth going on right now, there's been a little bit of confusion because we've had professionals issue a certificate and law enforcement go out there and they're basically doing a well-being check because they don't have the form. So you've got to work with local law enforcement in order to have a mechanism for which that document can get to them so that they have something substantial in order to do the pickup on that individual. And there's a reason in statute for law enforcement to do the pickup. Well, I talked briefly about transportation here in a minute. Ex parte is the other certificate, and ex parte is, in paraphrasing, is in the absence of, where a couple of individuals who know or are related to the individual can go to the courts and give written or sworn testimony as to the facts that support the rationale to have somebody taken into custody for an emergency evaluation or examination. All right. And again, the courts are that little word is there for the circuit courts as well. Circuit courts may enter an ex parte order, may being, again, a very interesting word here, because it allows, or again, the obligation is here, the courts have an obligation to figure out if least restrictive means to resolve these particular issues have been examined or even explored. So it's important to understand that the courts may say, no, you got to try these other services before you get to this level. Again, Baker Acts are serious things. We're talking about taking somebody's freedom away because we think they're so sick. So once the order is issued, it becomes a pickup order that is given over to the sheriff's department, because they're a county agency, and they have a valid time for within which to execute it within the next 7 days if there is no other timeline given within the court order. And they can do it anytime, day or night. So if at 2 in they know where Kirk's going to be and they got an order to go pick up Kirk because the family members and friends are very concerned about his decompensating mental condition, they can do so. And there are no court fees associated with folks doing that. And very often it is suggested to family members when they feel that from the professional side that we're trying least restrictive means, if they really feel that hard, they need that, they can make the case before the courts and have that issued as well. And let's talk about law enforcement, because law enforcement has been designated with the capability to go out and initiate an involuntary examination as well. The difference here is when somebody is meeting the criteria for involuntary examination and they're before law enforcement shall take into custody that person who appears to meet those criteria. Okay, so shall is a very strong word here. That means they do not have the option. They have, when that person is meeting involuntary criteria, they shall initiate the Baker Act. And in their Baker Act, which is a one-page form, and then there's a second form that they need to fill out for transportation purposes, but they need to outline or describe the circumstances for which to take the person into custody. So when they say the circumstances, they do not necessarily have to observe the behaviors. They can take into consideration credible third-party statements. So be prepared if you're one of those third parties to make a written statement for the officer if you want to assist them in that process. Because very often people pull it together when they see somebody with a badge showing up on scene and hold it together, and then you're like, the minute they leave, within a half hour, things are bad again. They do not have to screen for least restrictive means, and they do not have to personally witness the behaviors, like I said. But the change here is they shall. They got the criteria before them. If they feeling the person is meeting the criteria, boom, they've got to initiate. So that's one of the big differences between the professionals and the courts. We have the option to do some clinical interventions here. Whereas law enforcement, they don't have that additional training. They know that somebody's been called out there because of escalating situations that may present some harm to that individual or to others. And so therefore, they're looking for those key criteria. So when somebody is brought to a receiving facility, there's certain things that need to happen. And so they must be first and foremost examined by a physician without any necessary delay. So as soon as possible. Now, more recently, that has been clarified further with regard to minors. For minors who are taken into custody on an involuntary examination, they have to be examined within 12 hours. So whether that be in person or through a telehealth mechanism, minors have to be examined within 12 hours. So if at 3 p.m. a juvenile has been brought to a receiving facility, they have till 3 a.m, but they've got to have an appropriate professional do that evaluation and examination. Okay. They cannot be released without the appropriate documentation, and it is currently the psychiatrist or clinical psychologist who are legislatively marked with that responsibility to release somebody from their Baker Act. And they may not be held at a receiving facility longer than 72 hours. What has to happen in that 72-hour period is a full examination. And within that time frame, there's got to be certain conditions met. So when folks hear up to 72 hours, yes, it could be 3 days, but what we're talking about is sometimes less. And therefore, a decision needs to be made. If this condition cannot be stabilized within that short window of time, there has to be a court process that is initiated with a second psychiatrist coming in to provide what's referred to as opinions, a second opinion, and then it is brought before the courts, and court is held at each of the receiving facilities to review the case with the state's attorney. The client has their attorney or a defense attorney that's assigned to work with them. Psychiatry gives their testimony as to why they need to be there. The client has the opportunity to give their own statement during these hearings, and they can have witnesses brought in as well. And that could be family members, friends who can speak on their behalf in the course of care. So unless, of course, it's determined that by the psychiatrist that they can give express and informed consent, and they can change their status from involuntary to voluntary. But there's a whole court process. Then the courts decide a number of things. There can be an immediate discharge. There can be a continuance of a stay at the crisis unit, and that could be for various reasons, or it could be in order for the more restrictive state treatment facility or state placement. Once person is released, notifications go out there. Yes, people do get notified when people do get released. Their guardian or their designated representative gets a notification. The executioner of the involuntary examination. So if it's a clinician, they'll get notified. If it's law enforcement, that person is getting notified. Well, primarily their agency, not necessarily the individual officer, but the agency is being notified of that person's release, as are the courts. They get a notification, and the Agency for Healthcare Administration, which oversees the licenses for a lot of these facilities. So I'm looking at the time, and forgive me if I'm going very fast, but this is part of the process here. Sorry, jumped ahead on you. So that is essentially the quick down and dirty of what takes place. So they come in, there's groups that take place, there's examinations, there's conversations with a clinician. A lot of the main focus is how do we stabilize the current condition. With the Baker Act, you're basically buying an instant ticket to see the psychiatrist, because at that point, the psychiatrist is doing an evaluation for medication purposes, as well as some other courses of treatment in which clinicians and the staff here are working towards the aftercare. So it's not a long-term stay for adults or for juveniles. It's like, oh, okay, I can go off to the Bahamas for the weekend. Not necessarily. I mean, it's a short-term stay for examination. Okay, so it's involuntary examination. Placement takes place after a court hearing or what have you, and that's true with juveniles as well. There's other interventions that take place for juveniles that involve, youth at risk evaluations and groups of individuals who work in the children's services arena. Take a look at folks youngsters who may be at risk of being placed in residential care. And that is a lengthy process. It is not, they're here one day, they go next to residential. It can be months before juveniles end up in residential care. again, this is could be the jump start, and it could be the indicator of those longer term kinds of care. Now, there have been some recent changes with regard to juveniles. One of them being House Bill 945, and that has to do with some requirements within the schools as juveniles are acting up, or there are issues within the school system. House Bill 945 has required now since July 1st of 2020 that principals or their designees verify de-escalation strategies that have taken place within the schools. So it can be the school counselors or the mental health facilitators. What have they done? And at some point, if it's escalating to where we're almost getting to that Baker Act area, or even right on that edge, mobile outreach team needs to be consulted or come out to do a crisis assessment before law enforcement is called into play. Now, we've been fortunate here in Polk County. We've had a longstanding, very positive relationship with our school board, and have worked out even before this a triage process, which we ended up mirroring both in Hardy and Highlands counties with regard to, hey, if it can be handled within the school personnel setting, they can do that. They'll never get us involved. But if it starts to escalate, that's the second kind of layer of getting a mobile response team involved. And we bring in the school resource officers as kind of the last effort here to try to avoid the Baker Act. But essentially, if we're calling law enforcement, we're looking at a Baker Act kind of situation. Now, that law came out, and then on the heels of that, there was some additional pieces added through Senate Bill 590, which amended the Safe Schools Act, amends 391.0056, and more specifically paragraph 19 within the statute, which requires principals or their designee to make reasonable attempts to contact the parents and to get their consent for even the mobile response team's crisis assessment, or even the involuntary examination. So the question was, can parents refuse an involuntary? Well, where it kind of gets sticky within the statute is, do they have a willing family member who's going to help intervene here? If a parent's saying we'll do A, B, and C, and then they take their child away, that they can. The parents have rights to find care appropriately, and it doesn't necessarily have to be Peace River Center. It could be a private facility. It doesn't have to be Lakeland. It doesn't have to be Winter Haven. They can go to a private individual to get care, depending on their insurance means. So, but every reasonable attempt needs to be made to involve the parents. Now, when it comes to the schools, I know they've got a lot of forms that they get parents to fill out in the upfront, and some of that being consent for medical care and healthcare reasons, which is covered by some of the same statutes we're talking about here. So we've included the crisis evaluation in there, and parents have the option to opt out, at least in our area. And a lot of those details are being finalized because this is something that is fairly recent in happening. So parents are involved. For the mobile response team, we make every effort to contact the parents even during the assessment, because we want to know, did Johnny look like this before the school day started, or was he like this before? Are there things going on at home? So, and we need their inclusion, the parents, the caregiver, for aftercare as well. And to, especially if we're coming up with safety plans, we want those individuals involved. So we're calling them, when we call the parents. The schools are responsible for making sure that consent is there, or that consent has been withdrawn. And yes, you'll hear from the early months when we first were hearing about this, the mobile response team is, we can't go until we get consent. That has changed. We are responding while all those details are being figured out, so that we have a good response time. So once we get there, If the parents have declined the services, we act in a consulting role with the school at that point, and do the best we can, and won't provide the actual one-on-one with the child. So that's kind of how we've worked a lot of those kinds of issues. And that is still a work in progress that's taking place. I want to touch on transportation, and I'll do this real quickly because we're running out of time, and I want to jump in there for some questions. But bottom line, under statute, law enforcement in local areas have been designated the transport of choice. And that is because they have the vehicle setups, they have the capability to work with individuals who can potentially become violent and are unpredictable. Not everybody who falls under the criteria are violent individuals. And unfortunately, over the years, the issue of handcuffing and things like that have taken for officer safety and stuff like that. There's many agencies that have a policy if they're getting into the patrol car, the individual is going to be handcuffed regardless of age. Very often that is an agency policy, and sometimes officers will forego that based on their decision, but they often take a risk when doing that. Law enforcement has no obligation to transport individuals who are seeking voluntary admissions. Sometimes that does happen. That's more of a courtesy or a customer service being provided by that local agency. They do not have to assist in transferring individuals. There are contracts that happen with off-duty officers who help out, like at Lakeland Regional, Winter Haven, Peace River Center. Those are off-duty officers who have signed up for a special off-duty function to do that. But regardless of how that involuntary examination is initiated, whether it be through courts, whether it be law enforcement or an authorized mental health professional, law enforcement has to take them to the nearest receiving facility. The nearest receiving facility, with the exception of those with transportation exceptions, and we talked about those earlier. Now, the law does not reference where the nearest receiving facility may be, and it can be outside the officer's jurisdiction. In the northeast corner, Davenport, Haines City area of Polk County, there are actually closer receiving facilities in Osceola and Orange County. So many of folks will go into those facilities rather than come into Peace River Center, and may get aftercare in this area or may get aftercare in that area. Key thing here is that once law enforcement brings somebody to a licensed receiving facility and a designated receiving facility, the receiving facility must accept the Baker Act. They do not have to admit. There's a difference. They have to accept the Baker Act. They don't necessarily have to admit the person. And for law enforcement, that can tend to be, unfortunately, kind of an issue for them. Now, the thing you need to understand too is that freestanding psych facilities, they don't necessarily have all the medical capabilities that hospitals have. So if there are medical conditions, emergency medical conditions, basically broken, bleeding, or blue is how I've defined it, or paraphrased it of what's in the statute. If they need some serious medical attention, they need to go to an ER, and the ER gets the documentation of the Baker Act, and it then becomes the hospital's responsibility to find or locate an appropriate facility for them to go to, not necessarily the nearest, because transfers are a slightly different animal in those cases. So sometimes juveniles may end up at one location and get transferred out of the county. So you may see that happening from time to time. Okay, so we crammed everything in, and I'm a little bit over, but I do want to give folks an opportunity to shout out some questions via the chat or.
So we had one that came in early on, and I think one of your slides addressed it, but it might be a good sort of example. So a teacher observed cuts on a student's arm, referred the student to guidance office. Student was low risk on the Columbia Suicide Severity Scale, contacted and met with parent who is a nurse and who did not want intervention with the crisis mobile team and did not want to consider a Baker Act, but agreed to counseling at school. Student was released to go home with her mother. Principal was informed. Was this an appropriate resolution on behalf of the counselor?
Ooh, okay, good question. From everything that I got in that little statement, it would be, yeah, it would be. Cutting behavior isn't necessarily suicidal behavior, and utilizing the Columbia Suicide Severity Rating Scale. There are various iterations of that, but that is a evidence-based practice tool for assessing someone's suicidality, and the full scale that the crisis response team uses gets into how deep the ideation is and what are some of the suicidal behaviors, and that's all outlined in there. So even the screening tool that's utilized possibly through the school systems is good. They got the parents involved. That they felt that you've got a competent adult here who's willing to provide some care. Then yes, it now falls to the parent to do what's necessary. Good question.
So the least restrictive that you kept emphasizing.
Correct. Least restrictive. And you've got a willing family member to assist in care.
Anyone has any questions, feel free to type those in either to the Q&A or the chat. You can also raise your hand. We can do our best to unmute you. I know we had a lot of questions, so if anyone, okay, we're getting one right now. Can parents refuse a Baker Act? Sorry if this was answered earlier. That's okay. I know we covered a lot. So can parents refuse a Baker Act?
So really the parents need to get involved in the way things have started to fall into play with the House bills. Parents need to be consulted prior to initiating that Baker Act. Can they refuse? If they're saying they're going to get that child care, and I would say immediately, they can step in because of that long paragraph and those little words within that section. If you've got a willing family member to provide care, yeah, it now falls to that parent or guardian with regard to liability. It's keep finding out that follow-up piece. Did they actually go? Because agencies need to get release form signs and such. I know at the Peace River Center's crisis units, the clinicians can get into Mindshare. I think that's the name of it, where they can check and see if there's a case manager involved, and there can be notification done that way, as long as the appropriate releases are in place. And more often than not, we don't have problems. From time to time, we'll get a roadblock there.
All right, another question. Can Peace River Center case manager refuse a Baker Act despite psychologist or a mental health counselor request?
They
said case manager, but they would still have to be a licensed professional.
Yeah, they can. So I know with the crisis response team, we have some individuals who are bachelor level with X number of years of experience and additional training with regard to the Baker Act and suicidality scales. They're making recommendations with regard to that. Plus they consult myself personally and a few of our licensed individuals on staff with regard to that. Again, that has to do with, we're looking at our obligation under the law to look at least restrictive means, especially when it comes to juveniles, because going to a crisis unit, while they may think it's fun and a picnic, it's really not a fun place to be. So we're really trying to avoid disrupting that placement. Now, again, it's a recommendation that we're making at that point, and it would just be like consulting with another licensed individuals. If you get a crisis counselor that you're working with and they don't have the license, you're always welcome to speak with their supervisor and make the case as well. But ultimately, it's going to be law enforcement who, in a lot of these cases, will initiate. Now, I know the schools have some licensed individuals, and you can, based on your license, you can initiate Baker Acts. There are some policies out there that kind of limit your ability to do so. So I would check with your agency's or your school's policy with regard to that, to make sure you're following what you need to do. So I hope that answers that question.
We have, and I put in the chat too, I know, like you said, not a fun place to be, but definitely more like therapeutic. Like I know a lot of times people think, oh, I'll just go and take a break, but really, you know, they're putting in the work to get better, to develop coping skills. You know, there's groups, there's individuals. So
correct. Yeah, there are groups going on, there's psychoeducational stuff. They're meeting with a clinician, talking about aftercare, because we've got a plan. At the moment they come in, we're talking about how to get them out the door, and what services need to be in place. It isn't just, well, let's just hang around. Although in some cases it may appear that way, but there's group dynamics taking place. There's interventions happening one-on-one with folks, a lot more than what folks share.
well, I'm trying to find, we had a hand raised. I thought it said Marcia, but I'm not finding that on the list. Can't find my hand raised person. So now I can't allow you to talk. We had one comment. Oh gosh, I switched to the. So Christy Olson said, the Polk County school system does not allow licensed individuals to Baker Act. School counselors are not required to be licensed. So the ones that are cannot initiate a Baker Act.
Yeah.
Then before that we had, so a student is moderate to high level on the Columbia CSSRS, but student does not indicate wanting to kill or self-harm. Is it mandatory that the crisis mobile team be contacted? And I'm still looking for my hand raised person.
Yeah, I don't know that it's necessarily mandatory if that's the case with the scale, because the scale is a guidance document that helps kind of, it doesn't forego one's clinical judgment. So you may be a mental health facilitator working with a juvenile on those kinds of behaviors and thought processes. Because you can have individuals who have had a history of it, and you're working clinically with that person. Now, if you want a second opinion or just to kind of run something off somebody, you're more than welcome to call the crisis response team. We can talk you through some of that stuff. And hey, another set of ears or another set of eyes looking at things can never hurt, in my opinion.
That was actually one of our testimonies that was shared for one of our fundraising events, as we had someone from actually a technical school that said, you know, she has not only had the crisis team come out and help actually, you know, assess and you know, help students, but has also just been that second opinion of, you know, I think that X, Y, and Z, does that make sense? Yes, okay, great. And she would proceed forward. We have one more question. It says, and I'm a new counselor, and I apologize if you already said this, who exactly makes up the mobile response team?
Oh, okay. So the mobile crisis response team is made up of bachelor level individuals and master's level individuals. And some of the master's level folks are licensed. So those with bachelor's level have some experience working with individuals with mental illness and in crisis work, but they also go through about 145 hours of training before they are, you know, set off to do things on their own. They shadow a lot of other counselors, they're consulting, and even the licensed folks, we consult with each other with regard to what we're looking at, and it's in the assessment process. They need to reach out just to get that second opinion, that unbiased eye, and lots of times they're calling me personally because I'm not in that situation, so I can ask, you know, all the questions I want and say, hey, did you check this out? Did you check that out? So we have approximately, in its entirety, the staff from the crisis response team make up about 22 individuals. We have a few folks on night shift for the overnights who are answering our crisis line, which, by the way, I just posted the crisis line number there. It's 24/7. By all means, feel free to call and either request the mobile response team come out or request a consult from them over the phone, because the response team doesn't always need to come out. And that crisis line number is available to everybody. So feel free to give that number out. You got a 16-year-old who wants to call, and we've had some adolescents call our crisis line and speak to our crisis counselors over the phone, just to hear them out. Or doesn't necessarily, the response team does not need to go out just for Baker Acts. We're there to provide some intervention in a crisis situation and help de-escalate the situation. And actually, the team is trying very hard to avoid inpatient hospitalization where it's appropriate. Where it's appropriate, we're going to help you facilitate some of that.
A comment. I have heard how incredibly supportive your organization has been, not just to some of our staff, but to your employees at PRC as well. And I think what you said, Kirk, about the follow-up care is really important. You know, we want to set the individuals and especially, you know, our children up for success. So we have various children's programs and can connect them to other resources. Let's see, absolutely, Eunice. Eunice asked, should we give the telephone number to the crisis response team to parents? 100%. The reason is because summer, right?
Absolutely. Yeah, we, by all means, we've got parents calling us, we've got adults calling us, and we go into people's homes as well. And it's all initiated through a crisis phone contact that the individual has made. Law enforcement calls us out quite a bit as well. When they've got somebody that's, they're not really sure, but they know they need something, they'll call us out and we'll do an intervention. Now, we don't just do the crisis assessment. We're going to do some, as Jessica mentioned, we're going to do some aftercare as well, as far as doing a follow-up contact, whether it be by phone or even in person. We're doing more and more in-person follow-up contacts to make sure that they're okay. Is the crisis truly alleviated? Were there obstacles for you getting into care, whether it be through your insurance or whatnot? We'll help advocate for anybody to get into care.
One of the things I just put in the chat too is just that we also emphasize that it's not just for crisis, it's also emotional support. So I know we had a lot of young people utilizing it, and even parents who all of a sudden were now at home with their kids, and everything during the pandemic that happened, they were using it to really connect to resources as well. So
yes, and it was an interesting thing as the pandemic has gone on. We've seen a shift in the content of our crisis calls, not so much the volume. A little bump in volume, but what we've seen is the content shift from what's referred to as information referral, asking some questions and getting phone numbers, to more of discussions around anxiety and depression. And that's even a national trend out there with crisis work, as we're hearing more and more about anxiety issues and depression issues, specifically surrounding the pandemic.
We had Mr. Miranda and I, Crystal Lake Middle School guidance counselors, appreciate your clarity on these issues. Many thanks.
Oh, you're welcome anytime. And it's always muddy. I get it. If anybody has any questions, feel free to reach out to us. We'll be glad to clarify.
Absolutely. All right. Last call for any questions. Haven't seen any come through in a while. If you did have a question that didn't get answered, when we send out the recording as well as the slide deck, by all means, you can respond to that email. We will connect you with Kirk to get you some answers. Definitely, again, encourage you to share that number, use it. It is a free resource for the community. And like Kirk said, a lot of times his team is able to help de-escalate situations and can connect individuals, parents, kids to the least restrictive help and support. So thank you so much, Kirk. We are grateful for your time. Sorry we made you cram it into, I know we could have been here like a half-day session, but we appreciate your time and look forward to seeing everyone. We hope that you will join us again. Our Make It Okay webinar next Wednesday, or if that is not convenient for you, we can certainly schedule one that's convenient for your schedule. That really addresses the mental health stigma, mental illness stigma, how to have meaningful conversations, and so forth. So we hope you will join us for that, and otherwise have a wonderful rest of your day.
Thank you, everybody. Be well.